Good morning, this is Attorney Vince Davis. This is Get Your Kids Back Now. The show is dedicated to keeping families together and to fighting the tyranny of CPS and DCFS social workers. A secondary purpose of the show is to educate parents and relatives, or to at least show them where to get the necessary information for their fight. The final purpose of the show is to remind the people that change can be effectuated at the ballot box, at the state and federal levels. Let us unite, vote, and elect those who will make the necessary changes. Good morning, all. We have a show today, and I'm going to be talking about some requests that have been made via email to us, and I'm going to be talking about suing the social worker and the counties. In my opinion, there's been an explosion of litigation against social workers, and the cases that I'm involved in, rightfully so, in my opinion. And I'm not saying that all social workers are bad. The problem is that social workers have a lot of power, and power corrupts some individuals. And there are people calling me more and more to bring lawsuits against the social workers. So today I want to talk about the 4th and 14th Amendments regarding parents and children. And I want to remind people that those federal claims, are separate from state law claims, for example, under California law, or for example, under Arizona law, or for example, under New York law. The federal law is known as 1983. The official citation, and you can Google this, is 42 U.S.C. Section 1983. That's a federal law that protects individuals from government violations of their civil rights nationwide. Generally, cases against social workers come up in 3 or 4 areas. The first one is where the government violates the 4th Amendment. And that happens when they take your children without a warrant. And there have been many lawsuits brought by, very well-known lawyers in California and in other states about taking children without a warrant. The Ninth Circuit Court of Appeals has held that taking a child without a warrant, unless there's an emergency circumstance, is a violation of your constitutional rights. So generally those types of violations are called unwarranted seizures. Sometimes the violation comes where they do have a warrant, but it was based upon false accusations. And I mean knowingly false accusations. The next type of claim that comes up in cases is where the social worker has not been truthful with the judge. For example, in juvenile court or when getting a warrant, the social worker swears in a report or testifies on the stand to facts that just simply aren't true, or facts that are exaggerated. And they are misleading the court and are violating the civil rights of the parents and the children. The next type of case that I see commonly when you want to sue CPS is where your child is injured in foster care, or where the child has been injured in foster care, because there is a duty to protect children that are placed in foster care. So many times I get cases, and we have these types of cases now, where children have been physically, emotionally, or sexually abused while in foster care. And those cases happen too many, or they just happen too much. And I get the impression that in the juvenile court, sometimes I get the impression social workers try not to mention those injuries to children to the judge, and they don't put it in the report. And because judges are always mindful about the children that they are responsible for, they want to make sure that the children aren't injured. In Los Angeles County, it's so prevalent that the Los Angeles County Bar Association has a special panel of lawyers that represent children who are injured in foster care. And also in the state of California, there's a foster care fund where you can go to get compensation in case that the foster parent who does the tortious act doesn't have money to satisfy any particular settlement or judgment. And I said there was 3 or 4 types of claims. The 4th type of claim, and we file this in every case, and I've had people tell me, other lawyers, some judges, that these types of claims are called Monell claims, or sometimes difficult to prove. And a Monell claim is where the county or governmental agency has a custom or a practice or a policy or some type of training that is violative of your constitutional rights. For example, I was involved in a case a few years ago where, although the social worker didn't testify to this at the deposition, the sense that I got was that sometimes social workers exaggerate things to make sure they win the case, or to make sure what they're doing is justified. I was just involved in a case up in Yolo County, and I had a witness, an outside witness, who would testify that a conversation between she and the social worker didn't take place as the social worker wrote in the report. And the only thing that I could surmise was that the social worker said that to strengthen the case of removing the children and keeping the children removed. So that's the type of thing that sometimes I get the sense that there's some type of unwritten policy or practice among social workers to sometimes exaggerate or even twist what you say. Many years ago, social workers claimed they couldn't video or audio tape your conversations with them because it was too expensive. But nowadays, everyone has a smartphone, and it's very easy to tape a conversation between parent and the social worker. And I'm not sure why that's not done more often. In California, I should say, it is illegal to tape someone who doesn't know that they're being taped. It's actually a misdemeanor. And unless it falls under a few circumstances, that tape recorded conversation is not even admissible in court. So those are the different ways that you can sue a social worker. The 3 or 4 basic ways to sue the social worker in county. And I sometimes jokingly or half seriously tell attorneys all the time, in every juvenile dependency case or CPS case, there probably is some types of civil rights violation. Now, it may not be $1 million or a $10 million violation. Maybe it's a $10,000 or a $50,000 violation. But generally, you can always find something that has been done incorrectly in a case. There are a lot of things that happen in cases where the social worker, for whatever reason, doesn't follow the code or the law. For example, here's one that happens quite frequently. Your children are detained from you, and for whatever reason, the hearing is not going to be 48 up to 72 hours later. And the code says that you are supposed to have a visit with your child once the child is taken away from you, at least one. In a lot of cases, people come to me all the time and tell me, Mr. Davis, I didn't get that visit, and I'm wondering what's happening to my child or children, and I know my children are wondering what's happening to me. If we reverse roles and put ourselves in these children's position, it's a traumatic thing to be taken away from your parent and placed with strangers. I mean, I can't even imagine it for most children, especially children of tender years. Child's 3-4 years old, up to 7 or 8, they're taken by a stranger, placed with strangers, and they can't see or talk to their parent. I'm not sure that is doing what's best for children.